I'm John Strohmeyer, and this is the 5-Star Counsel Podcast. The market for legal services is shifting, and lawyers who don't adapt will be left behind. This podcast gives you a competitive edge in today's market by sharing the client service lessons you probably didn't learn in law school or in law practice. Let's start the show. Welcome back to the 5-Star Counsel Podcast. This week, we're talking with Megan Zavieh of Zavieh Law. While she focuses her firm on resolving issues for California lawyers with the State Bar of California, we're not going to be limited today. We're going to talk about how COVID has changed interactions between clients and lawyers and how the ethical implications of service will change how firms are dealing with things in the future. We're going to talk about things like meeting clients where they are, how to set up your fee agreements to comply with your ethical duties, and how you can set expectations for your clients in communications and other parts of your practice. With all that said, let's get to the interview. Hey friends, before we dive in today, I want to give a huge shout out to today's sponsor, Smith AI. Smith AI is an amazing virtual receptionist service for small businesses that specializes in working with solo and small law firms. My firm uses Smith, and they've been an invaluable addition. I literally rely on them every day as part of my firm's service delivery. With a range of services, Smith AI's friendly receptionists can handle your clients via phone, text, website, social chat, and beyond. They don't just answer the phone. They screen, schedule, chase your leads, and can even take payments. Let Smith's friendly gatekeepers staff your front line so you can work without interruptions. Their plans start at just $70 a month for calls and $100 a month for chats. Smith AI is offering a free trial, and our podcast listeners get an extra $100 discount with promo code 5STAR. That's FIVESTAR. Sign up and learn more at www.smith.ai. Megan, it's great to have you here. How are you today?
Thanks for having me, John. I'm good, and I miss seeing your face, so this is awesome.
I know. I'm really excited that we can actually record and see each other at the same time.
Me too. We're missing all our conference fun. So
I know. So many things now get done by video. At least we still had this. I don't think about it too much, but just realizing we're lucky we actually have technology like this to where we can still at least see each other.
Oh, absolutely.
So, well, welcome. You are one of our first guests on the 5-Star Counsel Podcast. And one of the reasons I wanted to bring you in, aside from your, the glowing introduction I've already given you, is really setting up ethical concerns that I think a lot of lawyers are worried about, but specifically talking about expectations and meeting clients where they are. So, we've talked a little bit about where we're going to go, but I want to kind of give you the floor first. Why don't you tell me kind of what you've seen and where you think things could be going wrong generally with clients or between clients and attorneys?
Oh, I would love to tackle that topic. And John, I'm really honored that I'm one of your first guests. Thank you. You actually have taught me a lot about client service. And so a lot of what I can share now, comes from my ethics background and defending lawyers in bar complaints, but also a lot of what you taught me about giving clients good service kind of gets all infused in here. So where I see so many lawyers going wrong is with setting expectations as to communication. If you look at statistics, which I'm not really advocating that everyone go start digging through their bar statistics and what happens with bar complaints in their state, but if you were to do that, you would find that the majority of bar complaints have a basis in failure to communicate. And we all have ethical rules that say we are required to communicate certain things to our clients within, a reasonable period of time. Mostly that is around material developments in their case. But that's not really what a client's looking for, right? They don't care that we just meet that ethical standard of telling them if something material has happened. They want to know all the time what's going on, and they want their questions answered, and they want to know how to reach you and that they can get a response in a reasonable amount of time. And all of that frustration that comes if those expectations aren't met lead to bar complaints. And one thing that is really important to think about in all of that is that a bar complaint, even if it's baseless and even if it does not lead to any discipline against the attorney, upends the lawyer's world, causes incredible amounts of stress, financial drain if you're hiring counsel to defend you. If you're not hiring counsel, then you're doing it yourself and taking time away from billable work. It's a big problem. So you can't approach this thinking, well, no valid bar complaint or no attorney discipline would come from this. You actually have to look at it as, I want no bar complaints. I want my clients to be happy. And of course, that also leads to clients who refer other clients and other good business, online reviews, all of that. So communication not meeting expectations, major problem. How do you solve it? Well, most attorneys that I'm seeing aren't addressing it up front. And that's why it's a problem, right? They're just going into an attorney-client relationship with all of their own expectations in their head, but they don't communicate them to the client. So maybe the attorney thinks, I hate email. I respond to emails once a day. And I really don't like being on the phone, but I'll text. Right. And they have all this in their head and the client doesn't know any of it. And the client comes into the relationship like, I'm a phone person. I want to be able to call my lawyer. I expect them to pick up. I like to be able to email and know I'm going to get a response in 10 minutes. And now they're completely on different wavelengths and it's not going to work, right? You're going to have an unhappy client no matter how good your legal work is. So lawyers can really be addressing this right up front with people. First of all, you might actually have to sift out some of the clients. Like there may be people you shouldn't work with because your expectations and theirs are so mismatched, it won't work. Such as if you're super tech heavy, right? You email, you text, you really don't like being on the phone for whatever reason. You just don't like it. It doesn't fit your schedule. It doesn't fit the way you live your life. And you have a client who hates all the technology and just wants to talk by phone. You're probably doomed from the beginning. But if you have that conversation up front and they're like, I'm really a phone person, and you go, oh, I'm really not a phone person, you might actually sift out some clients. And for the ones that you don't sift out, who you are going to work with, you should be laying out expectations for what communication with you looks like. It could be, don't text me. I really don't think it's secure enough. I'm not comfortable having sensitive conversations by text, so we're not going to text. But here's a method you can use. You can email me and expect a response within probably a day or so. Don't promise some specific number of hours. You will regret it. But, I try and get back to you within about a day. If it's really urgent, phone me. If you don't hear back, here's a backup number for my assistant. Then you'll lay it out for them. Mm-hmm. Here's what they can expect. And that should be somewhat tailored to the client. I mean, you shouldn't agree to expectations that you're not going to meet. So like if you're not a phone person, don't agree to phone expectations. Like you're just going to fall down on the job or be miserable. But you do need to hear from them. Like, what do you like to do? Like you may have somebody who says, you know what? I communicate mostly through my cell phone written. So it could be text or it could be email. But with my job, I just can't be available by phone very often. You go, okay, well then here, let's plan that our communication will be primarily by email. And now you've come to an agreement and an expectation. If more lawyers were doing that up front and having these conversations and setting those expectations, I think you'd see a real drop off in those bar complaints that at their core are simply failures to meet communication expectations.
You probably noticed me taking all sorts of notes because they're all sorts of things that I want to pick up on. But the first one I'm going to go with, though, is setting those expectations. It's crucial because if you don't set them up front, expectations are like other things in life. They abhor a vacuum. And if you don't set them, if you don't figure out what your client's baseline expectations are from the get-go, they're going to fill in the expectations on how you'll behave on their end. So by setting up front, this is how we're going to communicate. This is what we prefer, and this is how we work. You're letting the clients know, sometimes it's explicitly, sometimes it's not, but you're just letting them know this is how things work. So if somebody calls the main line, give away how my firm runs, if you call the main line as a new client, you're going to get scheduled for a phone call. It's rare that you will get through to talk to me on that first call, only because I'm setting the expectation of, I want to schedule those calls. You'll know I'm ready and prepared for you. And at the same time, you're going to be ready to talk to me about things. And the kind of on the other side of it is, I don't want my work with other clients getting disturbed just because the phone rang. That's going to break my concentration. And of course, that's its own thing. So to circle back on this, setting those expectations, what we're doing is, two ways of thinking about it. One, setting it kind of as an underlying, this is how it works. But another more explicit, sending a client maybe a PDF or just an email when they schedule that first call. Hey, thanks for scheduling. This is generally how we work. Phone calls are scheduled unless it's an emergency. And I think I heard that in what you were saying as well. But I define in my emails like as part of my signature. This is an emergency. This is when you can always call, because my practice is one where there aren't going to be a lot of immediate needs. Things can sit for a day or so, and I want people to know that. And so the things that are emergencies, define, again, not leaving that vacuum to the client to define what an emergency is. If you get a letter from the IRS, that is frustrating and upsetting. I know. I've received them on behalf of clients. I've received them directly from the IRS. Nobody likes that letter, and I know they want to get through, but those things always have time limits. You're not going to have to respond, 15 minutes after you've received that letter.
Right. Bar letters too, by the way.
Yeah. Exactly. Rarely. I mean, the only times you probably have this just happened and I need to respond immediately, it's probably a better sign that you're going to get scammed on something.
Yeah, that's a good point. In my practice, there's pretty much never this kind of an emergency that would really justify like ping my cell phone 16 times until I answer. I do give my cell phone number willingly, but not everyone does. But I'm not in criminal defense. No, my clients didn't end up in jail, or family law where the abusive spouse just showed up on the front lawn. Like that stuff doesn't happen. But when that is your practice area, you should account for that, right? You should tell your clients up front, oh, if you have an emergency and we know it could happen with what's going on in your life right now, here's how we can help you in an emergency. Here's the steps to take to reach us. Because that also reduces that client's stress, right? They don't go scrambling. Oh my gosh, abusive spouse is on the front lawn. What do I do? Where's their cell phone? Oh my gosh, and they're panicking, right? And you
schedule a call. I'll be available on Tuesday morning at 9 a.m.
Yes, exactly. Yes. We'll talk then. Until then, call 911. No, we don't want them having to do that, right? We want them to feel that we are there and that there's a process by which we can help them. So if a true emergency is actually part of your practice, that should be in those expectations. And you have to realize that too, like for your own designing your life and how you're willing to communicate, you have to meet the clients where they are. You have to recognize that because of the practice area you've chosen, this is the sort of situation your clients may be experiencing. And when they do, you need to be there for them through certain means. And so that process should be laid out ahead of time. And not only for the client, but you can go, okay, this is what I can live with. Here's my boundaries, so that this doesn't bleed into my life so much that I become a wreck and start committing ethics violations, because I certainly see that with the burned out lawyers, right? You have to protect yourself too. So here's a process I can live with that will also meet the client's needs. And I'm going to tell them up front, and I'm going to be prepared. And when this scenario gets triggered, here's what we can all expect.
Right. It's practice specific, and it's also part of the reason that I want people focused on one practice area or kind of a group of related practice areas. I do estate planning, some tax work, and probate work, and some like light business, but not mergers and acquisition level buying and selling companies. So that helps me figure out what my client emergencies actually are. And so I can tailor it to what my clients, like the clients in my sweet spot, deal with. But when you're dealing with the door lawyers who take anything or can kind of dabble in estate planning and litigation, and family law and adoptions and immigration and on and on and on.
Yes.
The problems just multiply because you don't have a good client persona that you can look at. You don't know what you're potentially facing on any particular client, and figuring out what those practice specific details are is going to be so much harder. And it's not to say you can't have multiple practice areas, but they need to be related, and you end up being much better at the focus than at just kind of dabbling in all of them.
Yeah, I agree with you on that. And I would add that it's a lot harder to develop the required empathy for your clients if you have clients experiencing 10 different kinds of situations.
Oh, that's a great point.
It's really hard to walk in their shoes. If I had an immigration client walk in, I could be like, okay, I kind of get it, right? I mean, I come from a family where we have some immigration. I'm my husband's first generation. So even though on my side, we've been here, I've seen his aunts and uncles and what they've been through. Okay, I guess I can relate. Well, no, I can't, right? I got a little bit of life experience. That's it. I haven't represented 200 immigration clients in the past year whose stories I've heard. And now, I get it, right? Think back to your first 10 clients in your practice area. How empathetic were you truly to them? Because you hadn't had enough experience with them yet. Well, if you have too broad of a practice with too many areas, you're going to have those first 10 clients are going to go on for 5 years because you're going the first 10 immigration clients and the first 10 family law clients. So I don't think you can develop that emotional depth to relate to your clients as well if you're spread too thin across practice areas.
Right. So I think one of the things that's important is when you've dealt not only with the similar practice matter multiple times, but when you've dealt with the same opposing parties or the same judicial staff or court staff. I know the probate staff, or at least, I know the probate staff at the probate courts here in Harris County, fairly well. To at least I'm familiar on a name basis because I do a lot of probate work. So I know who to email, who to call. There are some slight personality differences among them in the way that if I were to go to a district court or file, family law courts, I don't know any of those people. I don't know what the expectations are. By having dealt with the same people multiple times, you build up, your bank of trust with them. You also know what the actual common expectations are in that area. And it's similar for my work with the IRS. There are way too many people there. I don't know, a fraction of a percent of the people who work at the IRS, but I know from working with enough of them how things kind of work. I know the level of clients I'm willing to take on and the problems I can deal with there. So that helps me make sure that I'm not getting my clients in hot water. And I also know, I don't do any criminal tax. If they get way too hot for me, like my trigger word is willful. Because that's a defined term for tax purposes. Mm-hmm. When things start getting willful, that's my alarm. And I know when to send that on to my friends who do criminal tax, and it can handle the more aggressive or more dangerous aspects of tax practice. Because I don't want to dabble in that. I don't want to get my clients in more trouble because I didn't know what I was doing.
Yeah, that'd be a competence problem
right.
if you ended up in discipline cases.
Right. An aside, but only to say, just again, focusing in on what you're setting the expectations. You're setting the expectations on the way in for clients, not only just on communications, but on your own competence. And
absolutely.
I had a new client come in that is a doctor and his wife, who is a registered nurse, and they're thinking about doing some business planning. And that involves medical licensing, which is right on the line of where I feel competent and where I don't. And I already told them, I'm happy to start working with you. But, here are 3 things that I see in what you've emailed about that I may or may not be able to deal with. Here's one thing I definitely don't know how to do. And so you're going to be going elsewhere. And so this is something that we just want to line up on the front end. So it's just meeting the clients to make sure that we know what their expectations are. And so that if they're expecting to get everything done in one place, I may not be the guy for you.
That even goes to several things, actually. Meeting their expectations, fee agreements, conversations up front, all tie into that, because what your situation just totally triggered for me was plaintiffs' lawyers who are not tax attorneys. And so routinely, they are obtaining settlements for clients, some of which goes to attorney's fees, right? Which is a tax issue. Mm-hmm. That's a huge tax issue. And most lawyers are not competent to advise on that tax issue. So that's something that I see a lot in plaintiffs, like personal injury in particular, and employment law fee agreements. They'll say, here's a piece I can't advise you on. You should get a tax lawyer. Once we do get a settlement, some of it might be taxable. Don't count on me for that advice.
Right.
And saying that up front, I think a lot of lawyers, if they're disclaiming some portion of the work like that, they think they're looking incompetent to their clients, right? Especially a client who doesn't understand the complexity of what they are disclaiming responsibility for might say, what do you mean? What do you mean you can't advise me on that? They don't necessarily know that if they knocked on the next 5 lawyers' doors, they'd all say the same thing.
Right.
But you're better off doing that, setting the expectation for the client that you're going to need tax advice, and it's not going to come from me. And that protects both of you.
Right. I've seen that multiple times. Like I work with probably more family law attorneys on tax issues because they also usually have it as a line in their engagement letters. Like, yes, we're going to do whatever we're going to do. and we don't know what the tax consequences are. So I'll have a lot of conversations where I'm giving them at least, giving those family lawyers the outlines of what to expect and where they should pick up the phone and call me. And it's similar for PI attorneys because, I've heard multiple versions of this, and I guess it's probably not just with PI attorneys. PI attorneys who may be giving bad advice of, wash your funds through my IOLTA and then you don't even pay tax on it. That's a completely separate conversation about competence. But,
yes,
none of us can know all of it. We know, we have our deep level focuses. We have kind of the adjacent focus, but identifying for clients, you have a complex issue, and many clients, they do have complex issues. They may not think it's complex, but we've got to let them know.
A lot of them do think it's really simple. I certainly see that in my practice, and I only deal with lawyers. So I'm certain that it happens across all of them where someone comes, I just have this quick question because I have this really simple issue. Mm-hmm. And you look, I go, oh yeah, no, this is not a simple issue. This is, 16 issues that you don't even see yet.
Right. Well, Megan, this has been great talking. I'm glad that we had the chance to at least get started. Obviously, here we are. We've talked this much. I feel like we've barely scratched the surface. The things that I wrote down, meeting clients where they are, figuring out how they want to be talked to. You'll remember, I think it was the Clio report from 2018 identified clients mostly want to have their conversations in person, but we as attorneys think they want a phone call or an email. And hopefully Clio, one, hopefully they're listening, but two, hopefully they're identifying how these trends have changed thanks to everybody being locked up. I'm going to guess that meeting in person probably will still be on top, but we're going to have a new acceptance of FaceTime and Zoom and all the rest where you can at least still see people.
Oh yeah, this used to be, the last resort. Well, I guess we could video. And I remember having a conversation with a lawyer who said, I will never take on a client I haven't actually seen. It's okay if they want to hop on FaceTime for a minute, but I just want to see them for real because they did most of their work by phone. And now, with everyone being remote, this is just normal now. This is
exactly.
This is what we all expect now.
Right. Having this as a new normal is actually great because, I've got an office where clients can come and meet, but if we don't have to meet until we actually sign things, so much the better.
Yeah, I hardly ever meet my clients in person. If I do, it means that things have gone bad and we have to go to court. But even that's by Zoom now.
Right. All right. Well, Megan, where can we find you and get more information about you if we need that?
Well, you can always find me on Twitter. I'm at Zavieh Law, and my website is zaviehLaw.com.
Megan, how do you spell Zavieh?
Z like zebra, A, V like Victor, I, E as in Edward, H.
Megan, thanks so much.
I don't ever have to spell that.
No, never. I've never had to spell Strohmeyer either.
Oh, I'm sure. Well, thank you for having me, John.
It's been great. Talk soon. I'm sure we'll have you back.
Well, thank you. I'd love that.
Thanks so much for listening. You can find more info on us and get your free white paper on client service at 5starcounsel.com. You can get in touch with me at john@5starcounsel.com. If you enjoyed the podcast, please subscribe wherever fine podcasts are found and leave us a review wherever you can.